Good morning. You're Nathan Lamel, Senior. And Mr. Lamel was previously in court and entered a plea of true to count one in a motion to revoke deferred probation on probation for evading arrest or detention with the use of a vehicle. And that was from February 17th of 2025. Count one that he pled to was the count where he was arrested for a burglary of a habitation. It was not necessarily that he had committed it, but that he had been arrested for it.
And Judge,
Go ahead.
So you're aware, the motion reads kind of funny that you pointed out to us last time. So I could technically abandon 1 and 2. I just kept them there for your review. I have corrected them in 7 and 8. Believe.
Okay, so
That's
there
why
was a
it's
first amended.
Yes, ma'am.
So we need to go through that first amended.
Correct. And then Ms. Branch will be here to testify in place of Ms. Jefferson if those pleas don't change.
Okay, hold on a second. Let me pull this up correctly. So let's go through that motion. Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. And will he waive the formal reading of the first amended motion to revoke unadjudicated probation?
So waived.
So again, and this is 24 DCCR 0826. You have a first amended motion to revoke your unadjudicated probation. Shows you were placed on probation February 17th of 2025 for evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? It alleges you violated your probation, and I'm going to go through the whole thing again, just because I don't have the other one right in front of me. It'll be easier. So count one alleges that you were arrested. Okay, so did you want to?
Abandon 1 and 2, Judge, it shows that they were correctly reflected in the first amendment 7 and 8 committed.
All right,
That's
so,
what you didn't like the arrested for last time?
well, I mean, arrested for is fine, but it's not a violation
Correct.
of your probation.
Correct.
Okay, so 1 and 2 will be abandoned. So count 3 alleges that you failed to report as directed to the probation department March 5th and April 9th of 2025. And is that true or not true? True or not true?
True or not?
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true? That's marijuana, THC. Count 5 alleges that you were at a location other than your residence at approximately 3:01 a.m. April 26th of 2025 in violation of your probation. Is that true or not true? Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that on May 1st of 2025, you tested positive for alcohol. And is that true or not true? Count 7 alleges that you committed the offense of burglary of a habitation April 26th of 2025. And is that true or not true? And count 8 alleges that you failed to avoid injurious or vicious habits and refrain from behavior harmful to others, and that you were aggressive towards both Beaumont police officers and the complainant, Aronia Parkerson, on or about April 26th of 2025. And is that true or not true? Count 9 alleges that you provided a urine sample May 1st of 2025 that tested positive for ecstasy. And is that true or not true?
Your Honor, if I might, I don't.
This moment's all about paperwork versus perception. Defense insists everyone agreed to ISF. The state says, we wanted to see the PSI first. The judge finds ISF, cognitive, checked on the form, but no note to wait for that report. Translation: recommendation guarantee, and the judge flatly says she's not inclined to follow it. Here's the legal reality. Judicial discretion trumps expectation. What do you think? If it's checked on paper, should that bind the court, or should the judge decide based on current risk?
I think ecstasy is listed in the Controlled Substances Act. It would be MDMA. That's the rich street vernacular for methylene dioxymethamphetamine.
Okay, so if it's the same thing and it's just another name for it.
But I'm not sure that would be a violation. What would be characterized as ecstasy? If they want to amend to allege MDMA, that would.
Ms. Malfino?
I'll make that oral amendment, Judge, to change ecstasy to reflect MDMA as worded in the controlled substance.
All right, so any objection to that?
No objection.
All right, so that count 9 alleges now that you provided a urine sample that tested positive for MDMA, which is also ecstasy. Is that true or not true? Did you enter your pleas of true to counts 3, 4, 5, 6, and 9 freely and voluntarily?
Yes, no.
And because they're actually true?
Yes, no.
All right, so with regard to the burglary of a habitation, Ms. Malfino, what is the state's position as far as wanting to, do you want some time to
Judge,
prove that, or?
I will defer to whatever the court would like me to do. The complainant in that case has filed a non-prosecution affidavit and has also indicated to my office that she does not wish to cooperate in that case.
Okay,
I do believe Ms. Branch can testify with respect to that injurious or vicious habits in her reflection or read of the police report if Mr. Kimler wouldn't object. Otherwise, if you would like me to get those officers to detail his behavior on that night, I can do that, but she has not been cooperative with me.
okay.
Obviously, Your Honor, I would like the opportunity to cross-examine if the state does attempt to prove that up. I would just observe that whatever conduct Mr. Lamel did engage in didn't result in criminal charges being filed to the level of resisting or harassment or anything of that nature, retaliation.
So we already did the updated pre-sentence report, and the recommendation in that report, it was unagreed, and the recommendation at that time was that he would benefit from both tracks of ISF. Can't do both tracks, but to go in and do the substance abuse track, followed by JCDI, anger management. Ms. Malfino, since it can't go if the other case is pending, I guess based on what you're telling me about the complainant in the other case, what is your position on that?
To not proceed on that case, Judge.
Okay, so there'll be a dismissal.
If we
and
order him to ISF, I will file a dismissal today so that doesn't hold him up. But if that's also Ms. Branch's.
Is that still your position?
Yes, ma'am.
The judge recalls 4 people in the car, a shot fired, but no gun residue on Randall. That's why he's on a reduced robbery charge. But fast forward. Less than a year later, he's smoking weed, armed, and running from police. Those are true pleas to new violations. Solid grounds to revoke probation. Question for viewers. Does an old GSR test clear his name enough to earn leniency? Or do the new gun and evading charges seal his fate?
Cognitive track or substance abuse, Your Honor?
Well, substance abuse is clearly an issue. I think I would rather do substance abuse and then JCDI and then whatever other behavioral thinking,
You made sure.
moral recognition or something like that once he's out, and so that we get the more intensive substance abuse before he gets out for JCDI would be my thought. What do you, or would you think cognitive track would be better? You do? Okay. So what is the status of the relationship with the complainant? What's her name?
I'll represent to the court.
Aronia Parkerson. I'm asking him. I'm asking
I
him.
understand, but she's present outside of the court.
Okay. So what is your status of your relationship? Are y'all still together?
Yes, no.
Do you want to ask her some questions since she's here?
Maybe so, Judge, if I may. I didn't realize she was.
You want to go visit with her for a minute, or do you want to have her brought in?
Oh, we can just have her brought in.
Would you please call the name Aronia Parkerson? If you'll scoot over just a little bit towards your attorney. Ma'am, come right over here. You just come on up right here. Would you please state your name, please?
Ariana Parkinson.
And Ms. Parkerson, would you please raise your right hand?
Defense paints Randall as a young father who just needs structure. Calm in court, polite, and capable of change through ISF. But the judge is clearly focused on public safety. Carrying a gun and fleeing while on probation screams non-compliance. If you were the judge, Would you gamble on rehab again or say, enough chances? Judges walk a fine line. Offer hope, but not at the cost of safety.
Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Ms. Malfino?
Thank you. Ms. Parkerson, can you please describe for the court the nature of your relationship with the defendant, Nathan Lamel?
He's my boyfriend.
And is the gentleman in the orange to your left, is that Nathan Lamel?
Yes, ma'am.
Your may the record reflect that the witness has identified the defendant in this hearing?
The record will so reflect.
Judge, on Saturday, April 26th of this year, at approximately 6:15 in the morning, were officers of Beaumont Police Department dispatched to your home in reference to a burglary call that had been made?
Yes, ma'am.
Can you tell the court about that?
Me and Nathan had got into a disagreement. I really don't recall what the disagreement was about, but the first time they were called, he was trespassed, and officers explained to me that.
Here's the twist. The state drops 2 new misdemeanors just last week, another weapon charge and another evading. Those aren't even in the revocation motion yet, so the judge pauses the case for 3 weeks to allow amendments. That's due process. Practically, though, the more new cases stack up, the harder it gets to justify ISF. The judge also warns Randall, no more courtroom surprises. Keep your lawyer fully informed. Viewers, should a judge wait for every pending charge before revoking, or act now based on what's already proven?
If I called them back, that the trespass warrant will be voided. I was okay with that because I knew I was gonna call him back eventually. But he came back a second time, which made me call them again because he wanted to talk about whatever we had a disagreement about, but I didn't want to at that moment. I was going through the ride. I had just had my son a month prior, so I was dealing with postpartum. And at that moment, I just didn't care to hear what he had to say. But he knew I called the police back, but my dad was also in my house, and my dad wanted to talk to us both to see what the problem was between us, which is why he stayed, and he was arrested that night.
At approximately 5 a.m. that morning, or thereabouts, 5:20, were you awake and on the sofa in your living room, I'm sure probably with your new baby?
Yes, ma'am.
And what did you hear going on in your bedroom? Breaking of glass, rustling of things around?
Yes, ma'am.
And tell the court about that. What is it that you observed? Did you observe the defendant coming forcibly into the window of that residence?
I wouldn't say forcibly.
Had you given him permission?
No, but I heard him trying to open the window, and at that point I started recording a video just to get him away once the police was brought back.
Did you feel like that entry into your home was with the intent to possibly assault you based on what had been happening previously that evening and with respect to the nature of y'all's ongoing relationship?
No, ma'am, I don't feel that I was in any harm. He just wanted to talk.
So you don't believe that it was his intention to assault you, or that he could have possibly assaulted you in that scenario there?
No, ma'am.
But you still felt it necessary to contact the police on multiple occasions that night?
I just wanted him to leave. I didn't want to continue to talk about the situation. If he would have left the first time and then came back the next day, we could have revisited our situation. Just like when he was released 3 days afterwards, I think accusation is what it's called. He came back to my home and we talked about the situation, and moving forward, we've been good ever since.
Okay. Is that baby his?
Yes, ma'am.
Okay. And is it true that on May 10th of 2025, on August 7th of 2025, that you came in and gave a non-prosecution affidavit signed with Investigator Troy Robinson of my office, indicating that you did not wish to pursue the burglary charges against Mr. Lamel?
Yes, ma'am.
And is that what you're telling Judge West here this morning?
Yes, ma'am.
And has he pressured you or made you any promises or coerced you in any way?
No, ma'am. I did this of my own free will.
And do you understand that if those charges are dismissed, they're not going to be refiled?
Yes, ma'am.
And that you are taking your safety with Mr. Lamel into your own hands?
Yes, ma'am.
And are you asking the court to follow any agreement that she decides to make with respect to sending him to some substance abuse treatment, so that hopefully when he gets out, your relationship can be more effective?
Yes, ma'am.
and he can help you raise those babies.
Yes, ma'am.
Thank you.
No questions.
Thank you, ma'am. You can go have a seat. Okay. Not a good way to handle that situation, was it?
No, ma'am.
When you hear it out loud, how does that make you feel when you hear out loud what you did that night?
A little disappointed.
Not good for your baby, not good role model, not good for the relationship, and not good to keep you out of jail or prison, right?
Right.
So what I'll do then, based on that and based on her representations and probation's willingness to try to help you so that you can be successful, is I'm going to find that you entered your pleas of truth to counts 3, 4, 5, 6, and 9 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to follow this agreement, or not agreement, I'm going to follow the recommendation, and I'm going to continue you on probation. I am going to extend your probation for 1 year. I'm going to order that you enter and successfully complete the substance abuse track of the ISF program. And then when you're released, your aftercare will be through the JCDI program. You will also be required to follow any other new.
Switching gears. Toy Hill pleads guilty to assault family violence. The judge follows the deal. 10 years in prison, probated for 10, a $500 fine, and mandatory special needs SAFPF, a treatment program tackling addiction and mental health. The conditions are strict: complete treatment and no contact with the victim, even if the victim says it's okay. This is classic rehab with a hammer. She stays free if she follows the rules. Break them, and she serves 10 years. Would you call this fair, tough love, or too lenient?
Recommendations or classes with regard to making better decisions, cognitive thinking, things like that. This is all meant to help you be successful. I want to make sure you understand, though, that if you come back here again on another motion to revoke, you're probably not going to get the same. I'm sorry.
I'm sorry.
Yeah, no, you're not going to get all of this again. Does that make sense? You're likely going to be going to prison, and you could go to prison for up to 10 years. You could do that today. I could send you to prison for 10 years just for the violations you've already had that you agreed to, the testing positive and all that. I don't need a new case. I don't need any of that. I can send you to prison today. I don't want to do that. I want you guys to work things out, but you've got to make things where that works in a very productive and nonviolent and non-confrontational, sober way. Okay? So probation will let you know what all, again, that you need to do, but you'll go from here to ISF. Once you get out, you'll be in JCDI. No violations. Okay? All right. Good luck to you, sir. Give me just a second. All right. Are you Victavia Sanders? All right. Give me just a second.
So complete truth to the community service. Complete truth.
So there's still, our tablets are still messed up. And we only have one? We have two. Oh. Sorry, it's coming. All right, will she waive the formal reading of the motion?
So
Ms. Sanders, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. And so, Ms. Sanders, in cause number 22-39884, I have a motion to revoke your community supervision. Shows that you were placed on probation May 1st of 2023 for the offense of theft of property with previous convictions. And that was a 2-year state jail term that was probated for 5 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions July 31st of 2025. And is that true or not true?
Not true.
Yeah, not true.
Count 2 alleges that you failed to provide verification of performing the community services required. Is that true or not true?
Yes, ma'am.
It's true. Yes, that's true.
Not true.
Count 3 alleges that you're behind in your court-assessed fees as of August 19th, 2025 in the amount of $919. And is that true or not true?
That's true.
Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. But I'm going to reset your case for a sentencing hearing and ask the probation department to do an updated report. And we'll need, I guess, some time for witness.
Probably about an hour, Judge.
Okay.
We could do it at 11 o'clock on this.
Okay, so we'll reset it to where we have about an hour or so for any prove up of count 1.
And she's requesting a bond ground, although it is a straight probation case.
Has there anything been filed?
Should have been last night. But he felt, yeah.
Yeah, we're not having any trouble with those. He dropped it down. Sorry. Let me make this notation first. Mr. Smith, what is your position with regard to a bond?
State's opposed to bond, Judge. We're seeking state jail time and the new offense as well as.
Speak up, please.
The state is seeking state jail time in the new offense as well as the MTRP.
Okay, let me look at something and then I'll. I should be able to go back and see. Yep. So I'm going to take a look at the original precedence report. That'll just help give me some information about history and what got us here in the first place. No, that's denied at this point. This is her she's on probation for her 3rd felony and now allegedly committed her 4th. So that's denied. We'll get it set for a sentencing hearing and take care of it on that date.
Yes,
You can
Your
go
Honor.
back with the bailiff.
Okay.
Good morning, sir. You're Calvin Randall. And Mr. Randall has 3 cases, and 24 DCCR 1278, aggravated assault with a deadly weapon, 24 DCCR 1529, unlawful carrying a weapon on alcohol premises, and 24 DCCR 1530, and evading arrest or detention with the use of a vehicle. Mr. Eckhart, what is the announcement?
Judge, Mr. Randall was previously revoked on a different offense that's not listed here. Philip has made a very fair offer. And we were going to fill out a rejection this morning, but we need a little bit more time if the court will allow us. I think we're still kind of weighing our options.
Okay, and so what I'll do, any issues, Mr. Smith? So, Mr. Randall, I'm going to reset your case one more time. Mr. Eckhart will be out to visit with you about all your options, and we'll get an announcement at that next court date. All right, you can go back with the bailiff. Good morning, you're Traylon Hill, and this is cause numbers 24 DCCR 1500, 1614, 1615, and 25 DCCR 0436. And Mr. Matusko, what is the announcement on Mr. Hill's cases?
Your Honor, I believe I have all the discovery. Nothing has changed as far as a rejection.
Okay.
We'd ask the case be placed on the trial.
All right, then we will get that done at the first available trial docket and get it taken care of as quickly as possible. I understand that when it comes up, it may or may not be the oldest one, but based on the behavior and what the jail staff, and are we going, okay, we're going on more.
1, 2, 3.
Thank you. Let me get that pulled up properly. Are you Julian Garcia?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Garcia, in cause number 25, DCCR 1392, you're charged with the state jail felony offense of burglary of a building from June 26th of 2025. The indictment alleges you were previously convicted of theft of property, a state jail felony, February 5th of 2016, and that after that was final, you were convicted of unauthorized use of a vehicle.
Now to Larry Hancock, the courtroom's repeat flyer. The state lists 10 prior felonies and 7 evading arrests. He missed court, misbehaved in jail, and allegedly threatened officers. The judge's patience? Gone. She denies bond reductions, raises one bond to $100,000, and adds GPS monitoring plus house arrest if he's released. This is a masterclass in balancing rights and risk. High bonds to protect the public while still allowing due process. Question: is GPS and house arrest enough for someone with that record, or should he stay locked up until trial?
May 5th of 2022. And how do you plead to that charge? And are those prior convictions true? Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Let's see. So the agreement's for 10.
He was recently sentenced in drug court to a 10 year.
Okay.
The most he's received in the past, judges, several state jail sentences and 5 years.
Okay. All right. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Garcia is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty, and also find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will run concurrently with cause number 25, DCCR 0767. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.